Good afternoon, dear viewers. My name is Rajab Shahban, an advocate of the High Court of Kenya, practicing in the firm of Shahban and Associates Advocates. Welcome, all of you, to Court Helicopter Explained. Now, the previous speaker touched base on the Kadhi's court. He also touched base on how it is enshrined under the Constitution of Kenya 2010. Now, we've all heard about the Kadhi, the Chief Kadhi, but they're all governed, and for them to produce or pronounce a sound ruling, there are sources of law that they normally refer to. And according to the Islamic Sharia, we have two sources of law, which we consider primary source and secondary source. So for the primary sources of Islamic Sharia law, we have the Qur'an, which is the supreme law. We have the Sunnah, which are the teachings, the sayings, and the approvals of our beloved Prophet, peace be upon him. We also have what is known as ijma. These are consensus between the scholars. And finally, we have what is known as qiyas, which is analogical reasoning. For the secondary sources of law, we have what is known as istihsan. Istihsan, this is known as juristic preference. We have what is known as istishab, which is a presumption of continuity. We have what is known as maslahat mursala. These are unspecified public interest. We have what is known as shara min qablina. These are laws of those before us. We also have qawl or aqwal as-sahaba, which is known as the statements of the disciples or the companions of our beloved Prophet, peace be upon him. Finally, we have what is known as urf, which is custom. So basically, these form part of Islamic Sharia law and other sources which the scholars have worked upon in terms of bringing more light to this. Now, let's talk about divorce. And my explanation will be engulfed under the Islamic Sharia law. Divorce, which is the dissolution of a marital contract or a marriage contract. Marriage in Islam is considered to be a contract. And that's why you see, or you may hear, that is known as a mithaqun ghalidh. And divorce normally is initiated by a husband. And in some specific circumstances, we also have the wife who can initiate the divorce. The fundamentals and Islam places reliance and emphasis on reconciliation, number one. Okay? Protection of rights of spouses. Okay? It also touches on the waiting period of divorce. Now, divorce, which is known as talaq. We have talaq sunnah and or talaq sunni, or we have talaq bid'ah, which is known as innovated divorce. For the talaq sunni, which is considered to be the proper divorce, normally happens during a state of purity. So when the husband pronounces the first talaq to the wife, she's normally in the state of purity. And this one is normally revocable. So in the waiting period, the husband may take back the wife. And then we have what is known as talaq bid'ah, or the innovated divorce. Normally this is normally pronounced during the menstrual cycle of a lady, which is normally considered that she's not in the state of purity in accordance to Islamic Sharia law. We also have third or three pronounces of talaq. When a husband pronounces talaq or divorce 3 times in a row at once. And scholars, the school of thoughts have differed on this. Okay? But its validity still stands. We also have what is the circumstances or instances when a wife feels like she wants to seek for divorce. And normally, this one has something known as compensation, whereby she returns part of her dowry to the husband. Okay? And normally it's consensual. So the husband and the wife both consent to the same. Now, What are the instances, or what happens when a husband does not consent to the request of the wife to divorce the husband? Now that pushes us to the third one, which is known fasakh. Fasakh, this one is normally given out by the Kadhi, or an Islamic scholar. So for fasakh, there are specific circumstances. Normally when there is harm, when there is abuse, okay, when there is absence, and so many, and so on and so forth. Finally, let us talk about the waiting period. Now, the waiting period is the period after you have pronounced the divorce. So there are 4 categories. Normally, we have the menstrual cycle. For a lady who is menstruating, she has to undergo the 3 menstrual cycles. Number 2, for a lady who is pregnant and the husband has divorced the lady in the state of pregnancy, then the waiting period is up until she delivers the child. Number 3, for anyone who is in her menopause state, then those are 3 lunar months. Finally, for the widow, or a lady who has lost a husband, her waiting period is 4 months and 10 days. Okay? Now, we've talked about divorce. We've talked about the principles. We've talked about the types of divorces. We've talked about the waiting period. But there's something I had mentioned earlier on matters of the 3 pronouncements of talaq. Normally, this one, some scholars agree that it is pronounced as once. Others agree that it is 3 times. Now, when you divorce your wife the first time, which is the proper divorce, you've gone through the proper procedure, you can revoke the divorce, get back to your wife. You pronounce it the second time, you still get back to her. But now when you do it the 3rd time, then that marriage ends completely. And your wife must be remarried. And if she's remarried, they need to consummate the marriage. Then, if the husband or the current husband feels like he wants to divorce her, then he'll divorce her. She'll go through the waiting period, as earlier stated, and then you can now go ahead and marry her again. And in most circumstances, normally, when you let go, chances of you getting it back are very minimal. Okay? Now, we have what is known as revocable divorce, which is, and we have irrevocable divorce. So for revocable divorce, now, after the first pronouncement and the second pronouncement, you can get back to your wife through the waiting period. For the revocable one, this is khul, whereby the lady is the one who initiates divorce and pays a portion of her dowry. And also we have the divorce which has been pronounced 3 times. So the first, the second, or the 3rd time. So that is irrevocable divorce and the revocable divorce. Now, let's talk about succession. And this is one of the cropping topics which is really affecting most of the people who are in this country, especially Muslims and those who are not professing the Islamic faith. Unfortunately, we have Muslims who, and when I talk about Muslims, I'm talking about ladies. You see, in Islam, an Islamic or a Muslim lady is not allowed or permitted to marry a non-Muslim or someone who does not profess the Islamic faith. So, what are these principles? Now, succession, according to Islam, is defined as ilmul fara'id, the science of inheritance. Now, the basic principles of inheritance are enshrined in 1, the Qur'an, the Sunnah, which I talked about, the sayings, the teachings, and the approvals of our beloved Prophet Muhammad, peace be upon him. We have the ijma, which is the consensus, and we finally have the qiyas, which is analogical reasons. Okay? Now, what is the order of distribution? The deceased has left us. Now it's time to distribute a portion or his estate in accordance to the Islamic Sharia law. Number 1, the funeral expenses must be catered for. 2, debts must be offset. Number 3, the will should not exceed a third of the estate of the deceased. So if you are writing a will today and you are a Muslim and you're writing a will, then have this in mind that your will should not, and I repeat, should not exceed a third of your estate. Point to note that you cannot assign a will to your beneficiaries. You cannot write a will to your primary heirs. And I will talk about those primary heirs. Now, succession in Islam. Okay? Now, number one, succession in Islam, the principles of succession in Islam is that, number one, it is divinely fixed, okay, and highly structured. So you cannot change it. No man can change what has been fixed by our Creator, who we refer to as Allah or Allah. Okay? Both men and women are entitled to inheritance, but not of equal shares. Okay? Number three, a non-Muslim cannot inherit from a Muslim, and the vice versa. And finally, if you're writing a will, okay, it should not exceed a third of your estate. Okay? Now, let's talk about who are the primary shares in accordance to Islamic inheritance law. Now, for the primary shares, if you go to the scripts, they are normally referred to as Ashab al-Furud. These are called primary heirs. And their portions are fixed. Okay? The portions are fixed. If you go to the Qur'an, chapter 4, you go to the verses which are there. So verse 11, verse 12, and verse 176. They talk about the specific portions which are allocated to the primary heirs. And they are as follows. One, we have the husband, who is normally allocated half or quarter of the estate of the wife. If the wife passes on, the husband is entitled to a half or a quarter of her estate. Now, what about the wife? The wife is allocated a quarter or an eighth of the estate of her husband. The father, or rather the mother, to the deceased. So for the mother, she is allocated a third or a sixth of the estate of the deceased, that is the child. Now the father, a sixth, which is the minimum, okay? And then we have the daughter and the sister to the deceased, who in circumstances are allocated a half or 2/3. So we have the husband, which is a half or a quarter, the wife, which is a quarter or an eighth, the mother, which is a third or sixth, the father, who gets a sixth, which is the minimum. We have the daughter, who is allocated a half or 2/3. And finally, we have the sister, who is allocated a half or 2/3. So we are done with the primary heirs whose shares are fixated, okay, referred to as Ashab al-Furud. Now we go to the residuaries, or in other words, in Arabic, they are called asaba. For residuaries, normally after the primary shares have been allocated, okay, whatever remains is now again allocated to the residuaries, known as asaba. So we have the son, okay, we have the brother, we have the father in certain circumstances, and the paternal uncle, okay. And remember, a son normally gets double the share of the daughter or the sister, okay. So the male child gets double the share of a girl child, and strictly because Islam places sole responsibility of provision to the male. I know this is a very lengthy topic, we cannot discuss it further. Finally, we have those people who are referred to as kindreds or distant relatives. They are called Dhul Arham, okay? So Dhul Arham, they come in when there are no primary shares, there are no asaba, That is when they come in. So the kindreds or the relatives now come in to inherit the property if we've ascertained that there are no primary shares or primary heirs who are existent. Then there are no other closer relatives. Then the distant relatives can now inherit. And for example, we have the maternal uncle. Okay? Now, we have issues whereby different school of thoughts have differed on certain points on matters inheritance. Now, I want you to realize, and I want you to take note of this, that whatever differences that they are having on matters inheritance, then the differences are strictly procedural and not foundational. Why is this? Because the scholars all adhere to both the Qur'an and the teachings of the Sunnah, which are the teachings of our beloved Prophet Muhammad, peace be upon him. Thank you once again.